Now, our first conversation today centers around what the Chief Justice of Nigeria, Justice Tanko Muhammad, has said. Well, he ordered the chief judges of the 36 states and the Federal Capital Territory to ensure a speedy trial of criminal cases to ease crowding in correctional facilities.
Well, he urged them to consider the conditional or unconditional release of awaiting trial persons who have spent 6 years or more in custody. The Chief Justice, who doubles as the chairman of the National Judicial Council, gave this directive in a memo dated for May 15, 2020. The memo addressed to state chief justices was posted on the National Judicial Council's website on Friday.
All right, Mohammed said this directive, was in line with a call by the United Nations on countries to consciously reduce the population of inmates, since physical distancing and self-isolation in such conditions are practically impossible during the ravaging COVID-19 pandemic.
Well, joining us from Enugu, Southeast Nigeria, is Dr. Uju Agomoh. She is the founder, director of Prisoners Rehabilitation and Welfare Action, PROWA, a security, justice and development-focused non-governmental organization with regional, continental initiatives in several African countries, and she is also the former president, International Corrections and Prisons Association, Africa Chapter, ICPA. Thank you so much for joining us this morning.
Thank you very much.
All right. If you permit me, let me just breeze through the list of modalities that the president suggested to the Chief Justice of the Federation, who then suggested that to the Chief Judges of the 36 states. And these modalities include to grant conditional or unconditional release of awaiting trial persons to those who have spent 6 years or more in custody, those who have no confirmed criminal cases against them, those who are aged, terminally ill, low-risk offenders, those who do not have sufficient legal basis to remain in custody, those convicted of minor offenses with or without option of fines, and those who have less than 3 years left to serve. Now, with your knowledge of the custodial centers, how significant a decongestion will it make should the chief judges of the 36 states consider all of these modalities?
Yeah, first of all, I want to say that those modalities are usually the modalities that currently considered during the review of the prerogative of mercy committees, whether they be the state prerogative of mercy committees or the federal, which is the presidential prerogative of mercy committees, as well as the jail delivery processes that chief judges usually undertake in their various jurisdictions. So there's really not, so it's in order. That's the point I'm making. However, what is important, and I think this is really what I would love us to stress during this presentation today, is really the fact, how do we ensure proper institutionalization of this? How do we ensure that these are not things done ad hocly? And there are already laws provided that should enable us to do this as a matter of process, so that we don't get into a situation where we have a problem releasing persons and the impact is not there. You asked a clear question about the impact. And one of the things we can look at is perhaps if we look at the statistics as at, say, early March, and the statistics say around 11th of May, in terms of the custodial population, and we'll see that the margin is not much. I mean, this could be a little bit, and I can give you the figures. So as at early March, say 2nd of March, 2020, we had a situation where the total prison or total population in our custodial facilities were about 74,256 persons. Of that number, as high as 50,000 plus were awaiting trial. Okay? And about, say, slightly above 22,000 were convicted. Now, as at 11th of May 2020, when some of these releases have happened, what we saw was a slight decline from the total population of the custodial facilities, from the initial figure that I gave you, which was 74,256, to 67,227. And of that 57,227, we had awaiting trial persons about 47,000 plus. again, even convicted, was also reduced a little bit to about 15,000 points. But when you look at clearly and you see the impact, the statistics were now showing us in terms of the capacity of the facilities, we had marginally less than 3% in terms of the total population. So again, back to your question, the impact is not that much. We would want more, but to want more, to be able to ensure that a proper decongestion is done, it has to be institutionalized. And there are already processes to make that. And maybe as we go on, I will explain what those processes are.
Okay, so I want you to quickly clear this up for me, because we know that when we've spoken to you earlier this year, and we know that this entire movement indeed even started from the office of the president when he came out and gave a presidential pardon to 2,600 inmates. So does this apply to this certain number, or have we moved away from this, or would you need to go back and get another one? And also, when it comes to the speedy trial of cases and decongestion centers in the era of virtual proceedings, how do you reckon that being able to have the judges...
I didn't get your first question, but the latter part is a very, very crucial point, and I think is very, very commended. I mean, I think that's also perhaps one of the good things coming out of this terrible process that we have with the COVID-19 is the fact that we can't continue to do business as usual. We must understand there is great benefit in terms of, utilizing virtual platforms, because it saves a whole lot of problems. Yeah?
Dr. Agomoh, can you hear me?
Trying to get Dr. Agomoh.
Okay, go ahead.
So, transportation of this person to court and so many other things. So there are some benefits in terms of that. So, but your first point, I really did not
what I'm just trying to find out is if this number of people awaiting trial, does that fall under the presidential pardon that was granted to 26 inmates earlier this year?
To 2,600 inmates.
Yes.
What we found in the field was that as states were releasing, what we found in this field when we started analyzing the nature of those who have been released by some of the states, we observed that as states were releasing, some of those were the same, names that have been mentioned, the same persons that were supposed to be included in the 2,600, but also some were also others that the states, using their own powers, were able to include. And I think this is also a good thing. And that's partly the point I was trying to make to you earlier, that the key here is the issue of sustainability. Look at Section 12, subsection 4 of the Nigerian Correctional Service Act 2019, and up to even Section 12, subsection 12 of that same act. And you see the mechanism that have been put in place to actually institutionalize a MESS process that have an early warning signal, whereby whenever the controller of the states or the superintendent of the correctional facility observe that the population of that particular facility is exceeding the official capacity, he or she will trigger up this process to alert the chief judge of the state, the attorney general of the state, state prerogative of mercy committees, and all the likes of that, so that they can do something within 3 months grace that they had to reduce that population. And if we keep doing this consistently, the needful will actually be done. And we won't have to have a period where you need the federal government to remind us to decongest, or where we needed the COVID-19 to push us to a situation where we ought to decongest, but we actually will ensure that those who we have in our facilities are those who need custodial sanctions. And those who don't need custodial sanctions are actually processed out and are treated in the community through the non-custodial service of the Nigerian Correctional Service. And we will have a balance. The problem we have is that we are not striking that balance. And I have a strong problem with where you now say those we don't have records of, okay, release it. Good. Remember, there are those who we don't have records of that are also very serious offenders, and there are some that are innocent and have no reason to be there.
Okay.
Rule 6.
Okay. Go ahead, Dr. Uju. I'm enjoying the conversation.
The point I want to make.
Yeah.
Rule 6 of the United Nations Standard Minimum Rule for the Treatment of Prisoners clearly requires every jurisdiction, every country, every member state of the United Nations to actually have processes of documenting proper recording, whether it be electronic or whether it be in terms of hard paper, which cannot be tampered with. Why on earth should we have persons in custody that the police had not proper processes in terms of documentation? What has the police done in terms of ensuring that necessary files are handed over to the court to do the needful? I think this is really a dangerous precedent that we must really watch. And now that we are faced with this,
okay, we'll try to get Dr. Uju Agomoh back, but she's making very, very, very insightful statements. I mean, things you can learn a lot from. Take, for instance, Rule 6, really very apt. And when she comes back, what I'd like to talk to her about is dispensation of criminal justice in this country, because that's a really very important factor. She talked about something, striking the balance between custodial and non-custodial services. That's one thing we have not done a lot of. In this country, maybe it's the old colonial mindset. Anything that happens, you're tossed into the prison. A prison that is already decongested, a prison that is filled with a lot of people awaiting trial.
She's also brought the role of the police in all of this, but I do hear she's back.
Okay.
So, Rufai, go ahead with the
all
question.
right, so if you can hear me, Ma, I'm so excited that you're back here. I want to talk about some things real quickly. Number one, the power COVID has given us now as regards dispensation of criminal justice. I say that power because it might sound very funny, but the truth is we can actually take trials using electronic means, using face recognition means and Skype, Zoom and the likes and things like that. That's exciting. In fact, there was a prosecution done recently by an inmate somewhere that was sentenced to death via video camera recording. So that's one of it. How can we, expedite on criminal justice system? Secondly, I wanted to talk about the right of that prisoner, because a lot of people have come out to say it was wrong for you to have sentenced a man, via video conferencing and the likes and things like that. And furthermore, I want you to talk me through a roadmap how we can balance custodial services and non-custodial services, because there's a lot we can do with non-custodial services as regards development of society.
Okay. Are you hearing me?
Yes, ma'am.
Okay, I want to address this issue in two ways. I like the last question, so I want to spend a little bit of time dealing with the last question. But before I do, let me just say this. The law is supposed to serve the interests of the people. It is only a robot that will go ahead heading to danger, even when the danger stays before them. Now, think for 1 second. We have a pandemic before us. We know the things that can cause problem in terms of not maintaining social distancing or what they call physical distancing, or also having more people crowding the place. So we know that if we say don't have court sittings, and we can imagine how many people's rights will be deprived, how many persons will be there for a long time. So therefore, the comment I will make in terms of the use of technology, in terms of addressing what we need, is to ask ourselves, will it be in the interest of justice? Will it be in the interest of the community? Will it be in the interest of both the victims who have been, if their rights have been infringed, and also the offender, and indeed of the society, to speed up trial, if that trial process will need to be done virtually? That's the point I want to make there, and I'll keep there, and then go to the question about how do we balance this act between custodial and non-custodial. I think one of the greatest things that has happened to Nigeria is indeed what we saw in terms of the enactment of the Nigerian Correctional Service Act of 2019. Secondly, in terms of the role that have been given to the Nigerian Correctional Service to, under the same platform, provide the custodial service and the non-custodial service. Don't forget that the Administration of Criminal Justice Act of 2015, and indeed the Administration of Criminal Justice laws of many of the states, have provisions for non-custodial measures, primarily Part 44 and 45 of the Administration of Criminal Justice Act of 2015. But the question is that many of the jurisdictions are not applying it and not implementing it, with the exception perhaps of one, which is Lagos to some extent. Why was that the case? But because we did not have adequate platform to provide that support for that, which the Act have done. So now, if we look at correction as a continuum, and what is that continuum? It is not everybody who is in custody need to be in custody. Therefore, those people who don't need to be, so you may have committed an offense, but this is not such a serious offense that requires custodial. So why then bring you into custody and spend government money and spend the resources and time of correctional officers watching you 24/7? So you can then look at a situation whereby every petty offender, what for the sake of God would petty offenders be doing inside custody? That because you are walking along the road that somebody picks you and you are given a fine and you could not pay a fine of 5,000 or 10,000, you are kept in custody and you are fed. So just to round up on down your point quickly, just to say, so what the link and the balance is that you make sure that whether in custody or out of custody, there are correctional officers that are supervising. They are supervising people before they get to prevent them getting too hardened to get into the custody. They are also ensuring that those who are minor offenders or petty offenders are supervised in the community, and also those who have served their sentence, because you want to also make sure you assist them out in the community so that they don't relapse and going back into crime. So it's a holistic package. That's that balance that the custodial and non-custodial provides.
Indeed, this has thrown up a lot of issues. Technology has changed the way we are doing things, but there are also human rights issues embedded in them, like the case of Malaysia that Rufai mentioned earlier, where a man was sentenced to death via Zoom. When we look at speedy trial of cases, do you suggest that perhaps we should have special courts to assist the conventional courts at a time like this? That's one. Secondly, let's look at the payment of fines for those who are in custody because of their inability to pay those fines. Who takes responsibility? Is it a case of the state governments now paying themselves?
No, please, can you repeat your question because I lost you along the line?
Okay, so the first question has to do with the issue of speeding trial at this time. Would you suggest we have special courts to assist the conventional courts at a time like this rather than rely on technology, which you have raised some pertinent questions around? And secondly will be the issue of fine payment. You have mentioned that some people do not have any reason whatsoever to have been put in custody because of fines, minimal punishment. And so I'm asking you, because it's one of the modalities, who pays for those fines at a moment like this? Is it the state governments now having to pay themselves? How does it work?
Okay, on the issue of fine, let me just make it very clear. Prawa does not support paying of fines. Prawa does not support it, and I will explain to you why. The reason is that over the years we have seen that that is a way that many of the state governments are using as an income generating factor. And we tried that. We saw that in Lagos State. There was an instance where somebody paid a fine for 200 inmates during his birthday within a space of 2 weeks.
Right. I think
However, the point here being made is whether it's state or federal. So I guess the reason, I mean, this is not a question of who should be really paid, because sometimes you see individuals paying that. But I don't think that is the place for the federal government to play. I don't even think that the state government should be asking for that. It amounts to what you call criminalization of poverty. We're saying that there are different ways, especially when those fines are linked to petty offenses and minor offenses. You can have fines for other kinds of offenses, other kinds of economic and economic related offenses.
Hi there.
Please, for God.
Not to do my.
Go ahead. Sorry for the interruption, Dr. Uju.
Please, it is good to not to actually have use fines for those who are struggling with poverty. Because when they can't pay you the fine, you put them into custodial facilities and they mingle with hardened criminals. And what you are doing is you're breeding more insecurity to the community. Let me repeat. Prawa does not recognize, or rather does not support, the use of fines for petty offenders and minor offenders. That fine is better to address seriously issues of economic offenses. We should not criminalize poverty. The other point that you have made about the issue of balancing in terms of human rights, and I must say, speedy trial does not mean that we lose quality of justice. So every right that is enshrined in the Constitution and various regional and international human rights instruments of the inmates or the defendant or the accused persons should really be observed. So in other words, let me give you a very simple example. We look at Rwanda, for example. When Rwanda had a crisis in terms of the higher population of inmates during the genocide, they introduced the gachacha. That gachacha was actually trying to use a traditional means to resolve these problems and not put everybody in custody. So those people who accepted guilt and said they were sorry, depending on the type of offenses they had committed, if they were not the ringleaders, they were then moved to the gachacha court and they were given teach, which is like community service. They were given that. Now, it was only people who accepted. So in other words, we should not force people. If we have these options, we should be able to make it available, ask the inmate to decide whether they want a virtual trial or not. And if they say they don't want it, then we don't use it. But I'm saying is that this opens up a lot of opportunities for the justice system to actually help the process of administration of justice, and then we don't get the store cases or the congestions we get in the courts. So that is really critical to really bear in mind. So again, human rights should be observed.
All right, Dr. Uju, we do sincerely thank you for joining us on the show this morning. It's been very insightful, much appreciated.